Good morning and welcome to episode 76 of our Case of the Week series published in partnership with 𝐒. My name is Kelly Twigger. I am the CEO and founder of eDiscovery Assistant and the principal at ESI Attorneys. Thanks so much for joining me today. As you know, on our Case of the Week series, each week we choose a recent decision from our eDiscovery Assistant case law database and talk about the key issues raised in that decision for litigators, anyone involved in the process of discovery in litigation, and talk about the practical implications of that decision for you, on your practice, and for your clients. As always, either in the post that brought you to our Case of the Week this week or in the comment section of that post, depending on which platform you're viewing us on, you will see a link to the public link in our database for the decision today that we're going to discuss. You'll also see a link to an article from law.com written about the case we're going to discuss today from my colleague Phil Favreau at Innovative Driven. And you'll also see a link to last week's episode 75, which was Martley versus the City of Basehor from our eDiscovery Assistant blog. All right, let's jump into this week's decision. So this week's decision comes to us from the Southern District of New York. It's a decision from the 𝐊𝐴 Green Mountain single-serve coffee antitrust litigation. The decision was from April 11th of 2022 and is authored by United States Magistrate Judge Susan 𝐊𝐿𝐿. Judge 𝐊𝐿 has 30 decisions in our database, and most of them are extremely thoughtful, including this one. I recommend that you spend some time with this decision because it covers a lot of issues on information governance, scope of preservation, understanding your client's infrastructure, what counsel's obligations are regarding its duties to preserve and to work with clients on preservation obligations, as well as sanctions under Rule 37B and Rule 37E. Okay, as always, in our eDiscovery Assistant database, we tag each decision with issues from our proprietary issue structure. Issues for this week's decision include competency of counsel, legal hold, sanctions, exclusion of evidence, adverse inference, mobile devices, ESI protocol, spoliation, failure to preserve, bad faith, and costs and fees. Okay, let's jump into the facts on this decision. We are before the court here on competing motions for spoliation sanctions. So both parties, based on a schedule, brought motions for spoliation sanctions before the court. Because of the length of this decision and the analysis that goes into each party's motion for sanctions, I decided to split this case into two different sections for Case of the Week. So we've done that once previously with the DR Distributors case back in February of 2021, and it will really help us hone in on the analysis of those two parties' individual motions. So today we're going to cover the plaintiff's motion for sanctions, as well as the court's recitation of the standards under each of the rules and what's required for sanctions in the Second Circuit. Next week on Case of the Week, we will cover the defendant's motion for sanctions in this decision. Okay. You're going to see right away from some of these facts that the issue here for purposes of plaintiff's motion is one that we raise on Case of the Week quite often, and that is that timing is everything, and early planning and dealing with discovery from an early standpoint in the case is what's going to be key here. Okay. Let's talk a little bit about the parties. Keurig, as you probably well know, manufactures the Keurig coffee machines, as well as the K-cups that are used in those machines. The plaintiffs here are a collection of entities who also manufacture and sold the disposable cups that can be used in Keurig's coffee makers, and they compete with Keurig's K-cups in that market. The plaintiffs brought this class action against Keurig, alleging violations of the Sherman Act, the Clayton Act, and the Lanham Act, that by modifying Keurig's 2.0 model of its machine and designing new cups, which changed the K-cup design, they essentially worked to eliminate the competition that plaintiffs brought to the market. Okay, so that's kind of an underlying basis of where we are factually in the case. Let's talk a little bit about the timeline of the case, which, as we know on Case of the Week, is always one of the key factors in determining what issues are and what our key takeaways are. All right, timeline here. In February of 2014, 𝐊𝐞𝐿, who's one of the plaintiffs, files its initial complaint. At a status conference a couple of months later, in June of 2014, the district court judge states that, quote, he hoped that all parties, the plaintiffs and defendants, have done what they need to do vis-a-vis their clients on document preservation and encouraged the parties to meet and confer to submit a proposed protocol for electronically stored information, close quote. A month later, on July 1st, 2014, District Court Judge Broderick adopted the parties' joint ESI order. As part of that joint ESI order, the parties agreed to, quote, take reasonable steps in good faith to prevent the loss, destruction, alteration, overwriting, deletion, shredding, incineration, or theft of any document or data the party knows or reasonably should know falls within the scope of Federal Rule Civil Procedure 26B1, close quote. That's the language that the parties agreed to in their ESI order in 2014. Now, as of that date, both 𝐊𝐿 and 𝐈RIG represented that they had, quote, implemented a data preservation plan, issued preservation memoranda to relevant employees, and confirmed with IT personnel that auto deletions are suspended and that measures have been implemented to prevent the manual deletion of email by individual custodians, close quote. The parties also agreed to ask each of their document custodians whether he or she maintains potentially responsive documents or data in any of the electronic or hard copy sources that were listed in the ESI order, whether those documents were at the custodian's office, home, or online. And if a party concluded that a source of information listed in the ESI order was inaccessible, or that collection from or search of any of those sources would be unduly burdensome, the parties agreed to meet and confer to attempt to resolve those issues. So all of that information is included in the ESI order or was made as stipulations to the court in July of 2014. July 23rd of 2014, so just 3 weeks later, Judge Broderick grants limited discovery on 8 topics relating to the Keurig 2.0 brewer, including user manuals, design specifications, marketing materials, and the lockout feature, but otherwise staying discovery pending Keurig's motion to dismiss. Now, despite that stay by the court, the plaintiffs went ahead and issued several third-party deposition notices and subpoenas. The court stayed responses to those third-party notices pending a ruling on the motion to dismiss. Okay. On that same date in July, the plaintiffs filed a consolidated amended complaint. Now, let's fast forward. Excuse me. Let's fast forward to 2 years later. On August 31st, 2016, the plaintiff 𝐊𝐿 served its first set of requests for production on Keurig. On September 27th of 2016, so just about a month later, Judge Broderick ordered the parties to fulfill their custodian obligations and their search term obligations under the ESI order from 2014 within 14 and 30 days of the ruling on the motion to dismiss. So essentially, as we've seen in other cases, Judge Broderick gives the parties a heads up, hey, I'm going to rule on this motion to dismiss. And when I do, you need to be prepared to start producing information within 14 days on your custodian obligations and 30 days on your search term obligations. Fast forward another year, November 29th, 2017, the judge largely denies Keurig's motion to dismiss and orders that discovery should commence. With all the deadlines under the September 2016 order beginning to run on December 1st, 2017. So those 15 and 30-day obligations to agree to custodians and search terms now start effective December 1st, 2017. Now, Under that order from September 2016, the parties were to have identified those custodians and search terms by the end of 2017. Of the original 29 agreed upon custodians for 𝐂𝐸𝐫𝐢𝐠 that the parties identified in late 2017 and in early 2018, 23 of those were former employees. And of an additional 25 agreed on custodians identified during fact discovery, 21 of them were former employees. So you've got a lot of former employees from 𝐂𝐸𝐫𝐢𝐠. We're going to talk a little bit about the other changes that happened at 𝐂𝐸𝐫𝐢𝐠 from the time that the complaint was filed in 2014 up until discovery started running really in 2018. The time period for documents to be collected and produced was January 1, 2009 through December 31, 2017. So we're talking about an 8-year period. There was one exception to that time period, and that was an order requiring 𝐂𝐸𝐫𝐢𝐠 to produce documents in a related STIRM litigation that did not have a time period on it. The court found that the deadline for substantial production of the documents was April 30th, 2018, which was only 4 months after the court said go on discovery in December of 2017. So it's not very much time to deal with what will be an enormous amount of discovery. Now, one question that I have here is this completion of substantial production of documents. I've seen that come up a number of times. We've had it in cases in which we've been discovery counsel. It's very vague. What does it mean? What does substantial production of documents mean? I would encourage, if you get engaged with that language, to understand fully what that means so you've got an idea of what your obligations actually are at a substantial completion date. Now, subsequent to that April 30th, 2018 date, the court then extended the date for Treehouse, JBR, and 𝐂𝐸𝐫𝐢𝐠 to substantially complete their document production for the initial agreed upon custodians, as well as 12 additional 𝐂𝐸𝐫𝐢𝐠 custodians, 5 Treehouse custodians, and 1 additional JBR custodian. That date was then extended to January 4th of 2019. And January 11th was now the date for those third-party subpoenas and depositions that had been issued previously to be responded to. Discovery finally closed in the matter on May 20th of 2020. What we're looking at before the court now are motions that were filed on April 9th of 2021 on a set schedule by the court, and both of the motions brought by plaintiffs and defendant allege spoliation of evidence. As I mentioned, we're just going to start with the plaintiff's motion today, and we'll cover the defendant's motion in part 2 of this Case of the Week series. Okay, so what does the plaintiff's motion allege? Essentially, they've got 6 different things that they claim were spoliation by 𝐂𝐸𝐫𝐢𝐠. 1, a failure to conduct proper and timely custodian interviews. 2, a loss of hard drives for 9 different custodians. 3, an inability to access hard drives for 15 custodians. 4, a destruction of hard copy notes. 5, a failure to collect emails from its litigation hold repository. And 6, a delayed production of correct transactional data for experts' use. So essentially, on that last point, the plaintiffs claimed that they had done all of their analysis, and late productions by 𝐂𝐸𝐫𝐢𝐠 caused them to have to go and incur additional expenses to reconduct that transactional analysis. As remedies, the plaintiffs seek to exclude evidence on certain issues, as well as asking for an adverse instruction and costs and fees. Okay. Just for purposes of context, 𝐂𝐸𝐫𝐢𝐠 also brought a motion here that we're going to cover in our second segment, and alleging essentially also a failure to preserve and a failure to produce documents, and asking for exclusion of evidence. So based on the fact that we have competing motions here, the court asked the parties really to stipulate to a very basic timeline about the preservation notices that laid out the key events on the motions. The parties, over a several-month period of arguing about it, filed those stipulations with the court, with apparently a fair amount of argument in them. And the court held nearly 10 hours of hearings on these motions. So a lot of time and effort by the court in here, and it is obvious from the decision that's authored here as to the level of detail that the court considers for each and every custodian as far as data being lost, as far as prejudice and intent are considered for purposes of sanctions under Rule 37B and Rule 37E. Okay, so during the time period between when the first complaint was filed in 2014 and when discovery really started in 2018, Keurig experienced what all companies experience, which is an enormous turnover in personnel, both from a perspective of business personnel, custodians who would have actually had and maintained relevant data or data that needed to be preserved, I should say, as well as folks in the IT department. And so as a result, the facts in the case, well delineated by the court, lay out that, at one stage, Keurig used multiple different kinds of encryption software, the maintenance of which was not kept up by IT. And as a result, encryption passwords to be able to unlock encrypted drives were lost. And there was not the transfer of information from employees that left IT to new employees that came on that allowed for Keurig to be able to unlock those encrypted drives. So that's one issue. A second issue was the move from on-prem email to a Teams-based email approach using OneDrive, where email was stored in one central location, and users were starting to use shared drive locations as opposed to local hard drives. So those changes in the IT infrastructure at Keurig made discovery of older data. As we mentioned, data went back to 2009. It made a lot of discovery of that older data very, very difficult. Okay. So what's the analysis by the court on the plaintiff's motion for sanctions? Well, the court really begins by quoting some key language from Judge 𝐊𝐿𝐼n's decision in Pension Committee all the way back in 2012. And what the court is really looking at here is we've got a huge scope of information over a 9-year period of time, an enormous volume of custodians that are implicated on both sides for the plaintiffs and the defendants. And so the court thinks that it's really important to put context around the parties' preservation obligations. And so it quotes this language from Judge 𝐊𝐿𝐼n. In an era where vast amounts of electronic information is available for review, discovery in certain cases has become increasingly complex and expensive. Courts cannot and do not expect that any party can meet a standard of perfection. Nonetheless, the courts have a right to expect that litigants and counsel will take the necessary steps to ensure that relevant records are preserved when litigation is reasonably anticipated, and that such records are collected, reviewed, and produced to the opposing party. By now, it should be abundantly clear that the duty to preserve means what it says, and that a failure to preserve records, paper or electronic, and to search in the right places for those records will inevitably result in the spoliation of evidence. That's key language from Judge 𝐊𝐿𝐼n, and it goes all the way back to 2012. Okay, so plaintiff's motion here seeks sanctions under Rule 37B and Rule 37E, and the court then goes through what we've done on Case of the Week a number of times, the analysis for what parties must show for sanctions under both those sections. Rule 37B, of course, permits the court to issue an order directing that the matters embraced in the order or other designated facts be taken as established for purposes of the action, as the prevailing party claims, or prohibiting the disobedient party from supporting or opposing designated claims or defenses, or from introducing matters in evidence. Now, the court notes that in order to allow for an adverse instruction under Rule 37B, that the plaintiffs have to establish, one, that Keurig had an obligation to preserve evidence at the time it was destroyed, 2, that records were destroyed with a culpable state of mind, which requires that the party acted in bad faith through gross or ordinary negligence, and 3, that the evidence was relevant. So that's what we need to be able to get some sanctions under Rule 37B. Under Rule 37E, the court cites to the 2015 amendments to the Federal Rules of Civil Procedure and specifically addresses the spoliation under Section E1, which states that if ESI should have been preserved in the anticipation or conduct of litigation, and is lost because a party failed to take reasonable steps to preserve it, and it cannot be restored or replaced through additional discovery, the court may, on a finding of prejudice, order measures no greater than necessary to cure the prejudice. With regard to Section E2, the court also finds that we have to have an intent to deprive. And if that intent is shown, then the court can presume that the lost information was unfavorable to the party, or instruct the jury that it may or must presume the information was unfavorable to the party, or dismiss the action or enter a default judgment. But again, to get to those harsher sanctions, we've got to have that intent to deprive. We've discussed intent multiple times on Case of the Week and the high bar to be able to get there. Okay, so let's kind of dive into the analysis under Rule 37. And this court starts with looking at the duty to preserve, which is applicable to both Rule 37B as well as Rule 37E. The court notes that the duty to preserve attaches when a party should have known that the evidence may have been relevant to future litigation. When that party anticipates litigation, it has to suspend its routine document destruction policy and put a hold in place to ensure that preservation. Now, what's key here is that the court notes that reasonable steps to preserve includes an obligation by counsel to, quote, become fully familiar with her client's document retention policies as well as the client's data architecture, close quote. What the court is saying here is that counsel's obligations extend much further than simply advising her clients as to what documents might be necessary in a litigation. That's really important because we see a lot of instances where counsel simply ensure that a litigation hold notice is sent and then rely on their clients to take those preservation steps. And what the court's saying here is that counsel has that obligation. The court also notes that that obligation requires the counsel speak with information technology personnel who can explain the function of IT as it works in practice and take any affirmative steps to monitor compliance so that all the sources of discoverable information are identified and searched. Okay, so that's our standard for duty to preserve. Prejudice, we've covered a number of times here. The court notes here that relevance is not necessarily proof of prejudice, that the judges have the best course of discretion to determine how best to assess prejudice in particular cases, and that it is sufficient if the existing evidence plausibly suggests that the spoliated ESI could support the moving party's case. Of course, if evidence can be gained from another source, there is no prejudice. Okay, next, with intent to deprive under Rule 37E2, according to the court, Rule 37E2 contemplates not only the intent to perform an act that destroys ESI, but rather the intent to actually deprive another party of evidence. And notes that if an intent to deprive is found, no separate showing of prejudice is required because the finding of intent to deprive supports an inference that the opposing party was prejudiced by the loss of information. Now, there's a very interesting quote here from the court, which cites two district court decisions. And this kind of goes with the analysis that I'm raising regularly on the Case of the Week as to this high bar that we have for intent to deprive under Rule 37E. And the quote from the court says here, an intent to deprive can be found either from a conscious act of destruction or a conscious dereliction of a known duty to preserve electronic data. Now, that's a really interesting quote here to me because I'm reading the language, I'm seeing cases cited for it, but I'm not seeing that quote really put into practice by the courts. They're looking at affirmative actions or conscious acts of destruction as meeting that intent bar. And this notion that there can be a conscious dereliction of a known duty to preserve electronic data as meeting that intent standard, I'm not seeing that in practice. Okay. The court then goes through the factors that are required by the Second Circuit to determine the intent to deprive, and we're going to review those more in the context of the plaintiff's motion. Okay. We talked a little bit about the stipulations of fact that were put forth by both of the parties and the fact that the court was really frustrated with both of them. Well, one of the things that the court looks at here is that the plaintiff's submissions on its motion were sparse compared to its submissions on the stipulations. And with the stipulations, the plaintiff filed 400 additional pages that were not included with its original motion. The court says basically that's improper and we're not going to consider them. So, one of our key takeaways here is to make sure that when you're moving for sanctions, you're putting all of the information that you need in order to support that motion for sanctions, including the timeline on the duty to preserve, in the motion for sanctions and its supporting material. Okay, now let's look at the analysis of Rule 37B and Rule 37E in plaintiff's motion. The court finds specifically that Keurig's duty to preserve arose on February 14th of 2014 when it first received Treehouse's complaint. Now, the plaintiffs argue that Keurig's preservation and collection efforts weren't reasonable, ultimately because the data from 23 custodians was lost or irretrievable. That Keurig lost hard drives of at least 9 custodians, was unable to decrypt data from 9 custodians, could not image the computers of 6 custodians due to physical damage. And then there were hard copy documents that were not produced for multiple custodians. So the court looks really to the question of whether Keurig fulfilled its duty to take affirmative steps to prevent spoliation and examined that efforts with regard to the litigation hold and the custodian interviews that Keurig sent out and conducted, the hard drives and the hard copy documents. And all of this is really neatly broken out in the court's analysis. And again, I'm going to encourage you to read this decision because it's really going to instruct you on what steps you need to take for purposes of working with your clients on preservation. And when they have complexities like data that's much older than their current systems, there's going to be effort that's required to consider what preservation can be taken, what issues need to be raised with opposing counsel right out of the gate as far as preservation problems go or accessibility to data that didn't happen here. Okay, so let's talk a little bit about the litigation hold notices. Keurig sent litigation hold notices to 700 employees. However, the court noted that of the 54 custodians that Keurig agreed to as named custodians, that it did not timely interview 11 of those 54, which was about 20%, and it failed to send a litigation hold to 6 of those 54 agreed upon custodians, which was 11%. The court noted that Keurig did not interview 7 of the agreed upon custodians until after the January 4th, 2019 deadline for substantial completion. The court also notes the fact that some of the custodians were no longer employees, but that did not mitigate Keurig's preservation obligations. And Keurig kind of put itself in a bind here by simply saying, these are former employees. We don't have custody or control of any data that is in their possession. And the court said, hey, you got to have more of a sense of preservation than that. You've got to at least go to these former employees and ask them what they have. So to the extent they failed to ask some of those former employees, the court held that Keurig failed to meet its preservation obligations. In addition to that, Keurig's failure to distribute litigation holds to those 6 custodians and to timely interview those 11 custodians constituted a failure to comply with the ESI order that the parties agreed to. And that constituted an order under Rule 37B2A. The court noted that those failures also were a failure to take reasonable steps to preserve ESI under Rule 37E. So of all the efforts that Keurig took, and we're going to detail more of what they did later, just the failure to interview agreed upon custodians and to make sure that data was preserved for those custodians was enough to breach their duty to preserve. Okay, the court next looked at the issue of potential spoliation of hard drives of 23 custodians through whether they were lost, there was an inability to decrypt them, or they were damaged. Keurig collected, in this case, over 90 hard drives and laptops. That's a lot of hard drives and laptops, folks. Of that 90, 9 of those devices were inaccessible due to lost or inoperable encryption keys. 6 of them couldn't be accessed due to damage to the drives. So as a remedy for that information, which Keurig did not offer to plaintiffs until far into discovery in 2019, Keurig offered to provide a 30B6 witness, produce a chain of custody for that information, but also let the plaintiff's vendor try and access those drives. So the plaintiffs took the drives, got a vendor, but they were unable to get any more information off of the drives that were damaged or encrypted. Keurig was also unable to locate 9 hard drives for custodians who received legal holds but left before the discovery commenced in early 2018. So that's one of those situations where, had steps been taken in 2014 when those custodians were named, but still with the company, that could have been avoided in this situation. The court found that altogether 16 hard drives were inaccessible, 9 were lost altogether for 23 agreed upon custodians whose files should have been preserved and searched under the ESI order. And the court found that even if it infers that information became inaccessible due to the passage of time or in the ordinary course of Keurig's business, their failure to preserve the ESI was at least a negligent violation of the ESI order and under Rules 37B2A, and a failure to take reasonable steps under Rule 37E. The court also found that Keurig failed to take reasonable steps to preserve relevant hard copy documents for one custodian. And the court noted that although the custodian received a legal hold, he did not recall receiving it, and counsel had not contacted him until the summer of 2019. To ask for documents. So he received a legal hold allegedly in 2014, but nobody reached out to him until 2019. That's the gap that you have to bridge from a practical perspective. The court found that the failure to take reasonable steps to confirm that the custodian had received and complied with that hold allowed those documents to be lost, and therefore was another breach of the duty to preserve. Okay, next the court looks at prejudice, which is required under 37B2 as well as 37E. And the court looks, in terms of determining prejudice, the court looks at the whole of Keurig's efforts and really documents impressively all of the facts surrounding Keurig's efforts, which I assume were part of the stipulations and motion papers that Keurig responded to. And the court finds that in the 8-year multi-district litigation consolidating over 30 different cases, Keurig has issued litigation hold notices to 700 custodians, collected documents from 54 agreed upon custodians, as well as non-custodial sources agreed to by the parties, produced 3.8 million documents equating to 11 million pages, preserved and collected 99 hard drives, of which 93 were successfully imaged and over 70 were successfully decrypted, and produced 7 million pages of documents from prior litigations. In addition to that, the plaintiffs deposed 23 of the 30 custodians whose information Keurig allegedly spoliated. The plaintiffs also served dozens of non-party subpoenas to former employees and the customers and suppliers at issue in the litigation, and participated in dozens of meet and confers with Keurig, as well as 17 discovery conferences with the judge, and several others with an additional magistrate judge in this district. So that's a lot of effort on Keurig's part to be able to preserve information. And so as a result, because there are 23 different custodians that the plaintiffs claim the productions were deficient for, the court goes through each of the 23 custodians and does an analysis of documents that were produced for that custodian, sources that were searched for that custodian, and the role of that custodian, as well as the time period that that custodian was involved, to determine prejudice. As a result of that analysis, the court finds that the plaintiffs were prejudiced by Keurig's failure to preserve ESI for 5 custodians, and that plaintiffs did incur costs of undertaking additional measures to recover discoverable information from those hard drives. So for purposes of prejudice, that prong is met as to 5 of the custodians out of the 23. The court next moves to an intent determination under Rule 37E. And this is an analysis that we've done multiple times on Case of the Week. And I don't think we're going to see a lot of differences here, despite that quote that I mentioned to you earlier, where if you've got a conscious dereliction of duty with regard to your duty to preserve. Here, essentially, the court finds, as is fairly consistent with the facts, that there was no intentional spoliation by 𝐊𝐞𝐿, that the plaintiffs really here are seeking to prove intent through circumstantial evidence of counsel failing to conduct interviews, letting access to the encryption software lapse, failing to maintain a hard drive ticketing system that would allow hard drives for these individuals to be tracked, and other circumstantial evidence. And the court looks at each of those elements, but essentially says that none of them rise to the level of intent that is required. The failure to conduct interviews of custodians prior to them leaving the company was negligent, but that's not sufficient for intent. The court also found that 𝐊𝐞𝐿 did not act for the specific purpose of gaining an advantage in the litigation, which is really the purpose of finding that intent under Rule 37E. As a result of finding prejudice but no intent, the court then looks at what the available remedies are for the breach here. The court notes that it can consider the sanctions of preclusion and adverse inference under 37B2A because we've got the prejudice finding. The court grants the plaintiff fees and costs based on 𝐊𝐞𝐿's failure to acknowledge the issues from the drives and the lack of production, and it ordered the parties to meet and confer on what a sufficient basis for those fees and costs would be. The court also allowed the plaintiff to present evidence regarding the hard copy documents that were not preserved, as well as the gaps that were left by the failure to preserve hard drives for 3 custodians. However, the court does not find that an adverse inference is appropriate at all here. So essentially what we have is evidence preclusion on specific issues related to individual custodians, as well as costs and fees that are awarded, but no substantial sanctions against 𝐊𝐞𝐿. Now, as I mentioned, we'll take up 𝐊𝐞𝐿's motion for sanctions in part 2 on our Case of the Week next week. Okay, so what are our takeaways from the judge's ruling here, essentially granting the motion for sanctions for plaintiffs? Preservation language in your ESI protocol or order needs to be carefully considered. Courts are holding parties accountable for the language in those ESI orders. And in fact, the ESI order here and the failure to preserve information by 𝐊𝐞𝐿 was a basis for sanctions under 37B. Because there was no intent to preserve or no intent to destroy, had those preservation obligations either been met or had there been no language in the ESI order, there would be no sanctions here against 𝐊𝐞𝐿 because that lack of intent under Rule 37E, which is the standard on duty to preserve. Okay, next takeaway. It is crucial that when a case is filed, but you're sitting on a current motion to dismiss, that you have a process in place to identify and collect data that may be responsive. It is always going to be a balancing act as to whether or not to spend the money to engage early in the matter. But as this case shows, the process to recreate all of the history of what transpired here, to hire experts to try to decrypt drives and argue these motions was likely much more expensive than the initial data collection may have been. So what I'm advocating here is that you sit down, you have a legitimate discussion. I mean, we had 54 agreed upon custodians that were identified, not until 2017, but ostensibly that work could have been done in 2014. You could have taken a very targeted approach to what data needed to be preserved and collected. And we've seen in many, many cases that we have encrypted hard drives. We have hard drives that fail as a result of sitting around, that merely keeping hard drives with data stored on them on a shelf is not going to be a sufficient basis for preservation. You've got to take some active steps to make sure that that data is going to be available when you are preserving it. Okay. Now, it's very difficult and expensive to do this in such a large matter, but technology, all of the discovery in this large matter, but technology here really could have been a huge benefit. Now, we are talking about this going back to 2014, so it's a substantially different landscape in terms of technology than what we have today in 2022. But even as far back as 2018, 2019, when the parties were working on discovery here, there could have been a lot done to use technology to both identify search terms and really narrow what kinds of data needed to be produced, as well as be able to find what else might have been available in terms of finding alternative sources for data that was lost. So leverage your technology. As we've talked about, and we're covering both in UF events, I'm sure will be covered in other eDiscovery conferences, the cost of technology has dropped considerably, and the ability to use technology-assisted review is great on small cases and will save you a lot of money. Next takeaway is that this particular case was made very difficult by the age of the data being collected. This time in 2008, 2009 was still at a time where traditionally the IT departments allowed custodians to maintain data on their personal hard drives, as opposed to policies requiring information to be maintained on shared drives, or even locking down laptops, as happens now, more commonly now in IT departments, not across the board. And so as a result, it was really difficult to facilitate collection, and losses here were due to how data was being stored at the time, as well as encryption policies. So a lot more of that has advanced in the 10 years, not quite 10 years since this complaint was filed. And so you need to understand that when you're looking at historical data, that there are going to be different applications applied to it, and it's going to take a lot more time and effort to wade through that. Don't wait until the last minute. Okay, next takeaway, and this is an important one. The duty of counsel is well articulated by the court here, and it extends beyond just sending the legal notices and hoping that they're followed. We see that a lot, and the court notes here that counsel have an affirmative obligation not only to send out those notices, but to follow up with the custodians, make sure they understand their obligations, identify the locations of data to be collected, talk with IT, understand the client's systems, and make reasonable decisions regarding preservation and collection early. Finally, last takeaway, all facts on a motion for sanctions or a motion supporting a duty to preserve needs to be included with the original motion. If you don't include your affidavit laying out all the steps taken to preserve information, you are risking those facts not being considered by the court. Okay, that's our case of the week for this week. Thanks so much for joining me. We'll be back again next week with another decision on part 2 of this particular case. If you are interested in doing a free trial of our case law and resource database, you can hop to www.eDiscoveryAssistant.com and sign up for a free trial, or you can reach out to our team at support@eDiscoveryAssistant.com, and we can get you set up with a demo or for your organization or team. All right, thank you so much. Stay safe and healthy out there, and I'll see you next week.